Nowadays, people are talking about grandparent visitation or grandparent rights, and there is a actual filing that you can do seeking grandparent visitation. The courts have limited it somewhat and have not allowed it to be as far out as giving it that protection to other so-called de facto parents, whether it's a brother or sister or uncle or aunt or somebody else that's had an ongoing relationship with the children. However, grandparents do have the right to file for visitation when they go before the probate court asking that that would occur. They do have to show a really significant relationship that they had with the child, and why it's beneficial to the child to continue to have that relationship, even if the parents are opposed to it. You are able, if you can meet the beginning statutory requirements, you are able to go and have a hearing, and you can also try and negotiate something in order to be able to be part of your grandchild's life. You can also have defenses against it if the grandparent, if it's not in the child's best interest or the grandparents don't meet the statutory needs of what is required. Another issue is guardianships. And for guardianships of minors, it's where a parent is not able, willing, or fit to be able to care for that child. And a third party can petition the court either with an assent or an agreement of both the mother and father, or if one party assents or even both parties do not assent, you can go in and have a hearing. And again, you've got to be able to show that the parents aren't able to really care for that child, and that you're an appropriate caretaker for the child as well. Sometimes it's something that people try and do before DCF's involved or before DCF files a care and protection. Other times it's where the parents are saying that they're unable to care for the children, and you can do an assented to guardianship, or one parent says that they're not, or where somebody's in the situation where they might need help with a substance abuse or alcohol abuse situation, and you're just doing this on a temporary basis. You can get a temporary guardianship for up to 90 days and then go in for a permanent guardianship. Even a permanent guardianship, though, means is that the parent can come back and look that the guardianship be terminated if the parent is then able to adequately raise the child. There's also something called a caregiver's authorization, which isn't the same as a guardianship, but allows a grandparent that sometimes might be fairly actively involved with the child the right to be able to get medical records or talk to doctors and school people, being able to have some of the legal mechanisms that parents have that they might need. It is something that's a particular form from the probate and family court, and it is something that the parents can rescind at any point as well. But in certain circumstances, it can be a very beneficial thing where it's not as far as a guardianship or custody to a grandparent or some other third party, but allows the legal authority for the grandparent or whoever would be the caregiver to be able to get school records or talk to teachers or guidance counselors and doctors and things of that nature. And it's something that can be discussed. And the advantage with it, if you're a parent, is that you can always decide that you no longer want to have it, or you just want to have it for 3 months or 6 months or a certain period of time, and then you can revisit it at that point. And it doesn't give custody to that person.